What are the top 5 things to consider when you are setting up a revocable living trust? Number 5 is, first of all, why set up a revocable living trust? Isn't a will enough? Well, there are two ways to pass properties to your descendants or to anybody you choose to. You can either set up a will or you can set up a revocable living trust. Now, you can set up a will, but the only problem with a will is that a will has to go through a complicated process called probate. It could be simple, it could be complex, or it could get very complex, depending on a lot of factors. And it could be time consuming. So with good reason, people think, I just don't want my kids and my descendants to go through this complicated process. So let me set up a revocable living trust. A revocable living trust is basically a way to avoid probate, and you avoid the entire court costs, and your kids can get the money fairly quickly. It also has the added advantage of privacy, because if you go through probate or if your kids go through probate, what happens is how much money your kids have gotten is part of the public record, and anybody or any predator out there can access and find out how much money has gone to your descendants or your kids. But through a revocable living trust, that trust document is private, so nobody really knows how much money has gone to your kids. Number 4, what is a revocable living trust? A revocable living trust is basically, think of it like a box. It's a box in which you can put anything you want. You can put, your home, you can put real estate, you can put stocks, you can put bonds, you can put partnership interests, you can put oil and gas interests, you can put companies, you can put anything you want. Think of it like a box. The only thing is, after you pass away, the properties or whatever interest that you have put in the particular box, or which is the trust, that will be given away in accordance with the wishes which are recorded in your trust document. Number 3, who are the parties to the trust document? Well, you have the grantor, who is you, who is funding the trust, or who's putting money into the trust. You have the trustee, who is managing the trust. The trustee holds the legal title to the trust properties. And then you have the beneficiaries, who have some interest in benefiting from the trust properties, but they don't get a say in how to manage and control those assets. Now, the thing with the revocable living trust is that during your lifetime, you are the grantor, you are the trustee, you are also the beneficiary. So, you can amend it, you can revoke it, you can do whatever you want with it. After you pass away, then a successor trustee is appointed, and you can put out the names in the trust, and that trustee will then distribute the money that you have put in the trust, either to your kids or to anybody of people you've named, and you can give it to them outright, or you can give it to them in further trusts, so that if there's a high risk profession like a lawyer or a doctor who you have a child and they could get sued for malpractice and so on, and you just want to protect them, then you could give it to them in further trusts. Number 2, a pour over will. Even though you set up a trust, or even though clients set up a trust after leaving the attorney, and they have to actually transfer or retitle assets in the name of the trust, and 6 months later, a year later, people forget, they buy a car, they buy assets in their own names. So what happens is, even though the major assets are put into the trust, there are always these stray properties that still continue to remain in your name, or in the person or in the name of the grantor. Any stray properties that could not be put in the trust will be captured in a pour over will. The thing to note with a pour over will is that pour over will go through probate, but at least you're ensuring that minimal assets are going to go through probate instead of putting everything there, and that way you're trying to safeguard privacy. Number 1, what is the tax identification number of the trust? The tax identification number of the trust is, generally speaking, the social security number of the grantor, because during his lifetime, it's basically his property. Even though he puts it in a trust, he can amend it, revoke it, do whatever he wants. So the tax identification number is generally the social security number that is given to the grantor.